having business with the appellate to draw near, give your attendance, and shall be heard. Please be seated.
Okay, good afternoon, everyone. Whoa, we have over 6 hours of requested argument time. That takes us into 8 p.m. I doubt everybody wants to be here that late. So just to let you know, the standard speeches, we've read everything. We've read the record, read your briefs. Please ask for the time that you believe you need to get your point across. That said, case first up, People versus Hara Barocco.
Respondent, 3 minutes.
4, 1, and 3. Thank you. Second case is Cologne versus Thai Bout Estate. That has been information that we received this morning is settled. Third case up is McCants versus ACS. That's submitted. Fourth case, Paul versus City of New York.
Please, Your Honor, I need 10 minutes for cases. Respondent, 3 minutes.
All right, you get 5 and 5. Thank you. Fifth case up is RCI Hospitality versus White.
4 and 3, please.
4, 3, and 5. Thank you. Sixth case, People versus Jorge Colon. That's submitted. Kuhn versus WFP Tower. What? You said 10 minutes? Wait a minute, I got, how many parties are appealing here? 3. So you represent all the other 2 appellants? Okay, and you wanted 10 minutes, you said? All right, you got 5 and 2, you got 5 and 2 also. Invictus Global versus GE Engine.
Appellant, 6 and 3. Respondent, 5.
Okay, 6, 3, and 5, okay. People versus Ricky Hayes.
Appellant requests 6 and 2.
People request 6, Your Honor.
Okay, 6, 2, and 6. Eco Profits versus 450 West 34th.
Appellant 7 3.
Hang on a second. Okay, 7 and 3 and 5. Alexandra versus Doris. That's submitted. People versus Devon Stallings.
Appellate requests 5 and 2.
Respondent requests 5 minutes, Your Honor.
5, 2, and 5. Bill versus Zoel.
Appellant requests 6 and 3.
6, 3. What? Hold on a second. Whoa, hold on a second. I only got one set of respondents. You represent who? Okay. And you represent? Okay. We'll do this 6, 3, 5. How much time you want? I'll give you 4. Thank you. Okay, Franklin versus Franklin. 6, 3, and 5. Okay. U.S. Bank versus Kim. You're here by yourself. You're going to argue amongst yourself or against yourself, or you want to submit? No. Just to let you know, I believe there's a motion that was made too, so we're going to be addressing that too, okay, in whatever we're going to have to look at when we go back in, okay? So it's submitted, thank you. People versus Robert Wright, submitted. Fishbein versus Goldman, submitted. Okay, is that something I said? People versus Merriwall, submitted. Okay, Upfront Megatainment versus Thame, that's submitted. Bezunia versus Allstate Insurance, that's also submitted. And Sammy versus Rosado, it's an original proceeding, that is submitted. Okay, terrific, thank you. Oh, okay. You still can. First case up, People versus Harold Baracco. Okay, you may be seen. Thank you.
May it please the court, my name is Paul Wiener, appearing for appellant Harold Baracall. The weapon possession conviction makes absolutely no sense under the particular circumstances of this case. In order to have acquitted appellant of all of the other...
Justification is not a defense to a weapons charge. So the justification, which may have been credited by the jury as to the other charges, doesn't get you out of the weapons charge.
I understand, Your Honor, and under other circumstances, that would be correct. Under the particular circumstances of this case, however, this is not a situation in which there was evidence that Payano was charging at my client with a weapon, for example. So it's not a situation in which the jury could have found that the appellant had an illegal weapon, but that the circumstances of the particular incident alone were such that would have...
Are you trying to argue that, from what I understand, is that because there were the acquittal of the 4 other charges, is there sort of an inconsistency here? How could he get acquitted of the 4 other charges and then be found guilty of weapons possession?
Exactly.
Is that what you're arguing?
Yes, and we're saying that in order to have acquitted him of all of those other 4 charges, the jury must have believed not only Payano's testimony, appellant's testimony that Payano had threatened him during the incident.
You're not really making an inconsistency argument. You're doing this by a weight of the evidence argument.
It's a weight of the evidence. The jury, in order to have reached that conclusion, must have
So wasn't the weapons possession crime completed when he pulls out the knives?
No, because in this case, again, the jury must have believed, in order to have acquitted him of all of the other charges, the jury must have believed that Payano had threatened his life.
There's a little bit of a, I'm not so sure that, because I looked at the other charges, and the intent for those other charges are either to intent to injure or serious injury or to kill, right? Right? With those other charges. Here on the weapons charge, it's a very different intent. It's an intent to unlawfully have something to use, so that there is really, so the fact that there was an acquittal on the other 4 charges doesn't really impact the charge that he actually got convicted on.
It does, because under the facts, in order to have reached that conclusion of justification, the jury must also have concluded that Payano had threatened my client's life the night before, because we have the video. Again, the video...
Yeah, but that's very different from the fact that the fact that you have to prove on the weapons charge. No, those are 2 different things, right?
But if the jury believed that my client, his life was threatened the night before, Payano had
But
threatened
picking
to
up
kill
on
him.
what Judge Ung said, and as you look at the video of the stabbing, so these were big knives, right? I mean, you look at it, it looks like a really, you know, when he sort of cuts the Payano in the face, but maybe the jury just didn't believe that he intended to kill him.
Well,
Right, a serious injury or death. I mean, as Justice Friedman says, I mean, there's a little bit of a slight wrinkle there.
Right, well, I mean, but it was also, there was also the other assault charge, which was just physical injury. Again, the whole defense here was justification. That had to have been the reason why they acquitted him.
Yeah, I'm not, yeah, but as we said, justification doesn't apply to this weapons charge. So then I have to peel it back another layer and say, well, what is it exactly we're talking about here? And it's exactly that, right? I mean, it's the different elements.
And
You can think about that on reply. You could get it on reply.
Thank you, Your Honor.
Thank you.
Appreciate it.
Good afternoon, Catherine Triffon for the respondent and the people. If it please the court, the verdict did make sense. The jury was justified. Where the evidence showed that the defendant took the knives from his house, secreted them in his
Yeah,
coat pocket.
but doesn't defense counsel make an arguably good point that when you look at the video and it's how clear cut, there was this attempt, not this attempt, this actual stabbing. So for the jury to have acquitted on these other counts means that they had to have credited the justification. So if they credited the justification, how could you have the unlawful intent which you need for the CPW?
Well, as Your Honor pointed out, the justification doesn't cover the possession of the weapon. However, to that end, the defendant testified that he brought the knives the night before, he thought to bring the knives before, he packed them with him that day because he thought that at the very least, not that he necessarily intended to use them, but that he would scare his coworkers and the complaining witness into leaving them alone. That forms the intent, and therefore it would have been unreasonable for the jury to acquit him of the possession. He hid the knives, he brought them to work, he hid the knives, he was not under direct attack when he pulled them out. This court has consistently found that even in incidents where the defendant has been acquitted of assault charges, attempted homicide charges, even if you are bringing a knife or a weapon to a confrontation to defend yourself with, it still shows an intent to unlawfully possess it.
Right, but the intent to use that weapon against another, isn't that paired also with the assault and the attempted murder charges? That what was he going to do with these knives? They weren't in his pocket. The video depicts what he did with them.
The intent can be divorced. The intent to possess a weapon unlawfully is formed when he brought them with him to scare his coworkers. It can be divorced from, as the judge pointed out, the jury acquitted because perhaps they found, and we can't divine, right? Perhaps the jury found that the injury wasn't serious enough, or that in the heat of the moment he didn't mean to cause the injury that he caused. However, he did mean to bring the knives to intimidate his coworkers, to get them into leaving him alone. That's an unlawful intent. The cases that I've cited that are parallel with this, where defendants have been acquitted of higher charges but have brought knives or gone back to get weapons after they've been confronted, after something has happened, this court has consistently found an intent there.
Okay, thank you.
Thank you.
Just very.
Counsel, if I may,
Yes.
I'd like to follow up on that last point with respect to the defendant's testimony that he, took the two knives to scare the coworkers. Why isn't that enough with respect to intent, particularly since, as counsel indicated, we have ruled on this before, Perez and other cases?
Understood, Your Honor. Actually, I think counsel is referring to page 531, and page 531 of the record, this is, he says when he left the house that morning with the kitchen knives, quote, "I didn't have the intention of stabbing him. I know that I took the knives, but I thought that perhaps when they arrived and I felt in danger, I would take out the knives." That's why he says he brought the knives to work. So that, and again, he had just been describing how the night before they had threatened his life. I just want to emphasize, under the particular facts of this case, it would have been impossible for the jury to have found justification without believing that my client's life was threatened.
How do you distinguish this case from Russell, where the Court of Appeals, based on facts which seem analogous, that it's not, inconsistent?
I mean, again, I just think, this court has the obligation to act as a 13th juror. And again, this particular verdict under this particular fact, given what we know in the video, just doesn't make any sense in terms of the conviction for the weapon possession. Thank you so much.
Thank you. Paul versus City of New York.
Good afternoon, Your
afternoon.
Honor. My name is Harvey Levine. I'm the attorney for Mr. Paul. May I reserve 1 minute of my 5 minutes to respond to counsel?
You should have asked for that.
I should have.
Okay, go ahead. You got 1 minute.
Should have. So basically, this is a case involving the Department of Correction, a correction officer. It involves two different people. The first person is a gentleman by the name of Ferrantovich, and a criminal. He came from another institution. When he came 2.5 months before this happened on this evening, he had an underwear that had been looked at the institution, the record reflects it, that was packaged in a bag and that was brought to the new institution where he was, I believe it's Rikers.
Counsel, I think we need to focus on whether the captain,
Okay,
your client, the former captain,
I have, yep, no problem.
your client did not follow the return of inventory protocol. I'm keeping it simple, but the record is clear that there are a number of steps that have to take place to ensure that the very item that's being returned to the inmate is as simple or not problematic here. And we have a situation where, unfortunately, the inmate obviously found some fentanyl in his shorts and eventually OD'd. So how do you explain a
Yes,
captain?
I'll be glad to explain it, number one.
But before, I want to add to that, because this was, I think, after midnight and didn't follow the proper protocol, so we can bring both together.
I'll be glad to. Number one, there was no special order directing any officer, if they wanted to remove anything from the property clerk's office, that they had to have the inmate sign for it, bring it down. There was a general promulgation. If you read the record, Mr. Miller testified for the department, and Mr. Miller said, no, there was no general directive. There was a specific underlying directive, but no specific routine, no order. This was being done on a regular basis. One of the reasons why, Your Honor,
Counsel,
the-
didn't
Sorry, Your Honor.
the property captain, Little, didn't she describe that process based upon a directive? And also that she had, that your client was aware because she had described it and informed him of how it was supposed to be done?
I'm sorry, Your Honor, I missed what you said, forgive me.
There was a witness who testified at the hearing,
Yes,
Little. She talked about the directives in terms of how you take property out. She was in fact the property captain, right? And she had explained to your
Yes.
client and knows that your client was aware of the directive because she had explained it to him and informed him of such.
I don't think the witness explained to the client, but once again, there was a general understanding, but no specific directive that if you want, by the way, this was being done on a regular basis. One of the reasons, Your Honor, the respondent failed to bring a property clerk. If that was in effect, then a property clerk would have been notified that you cannot give any information or any bit of clothing to anyone without a signature and without
Veritovic is not the petitioner's only problem. He's also got the Clark chokehold. He put Clark in a chokehold, didn't he? Which is not.
The second inmate, a chokehold.
Oh, yeah, that's another case. But I wanted to finish with this case, and I'll be glad to go to that case.
It's another case, but his termination is based upon both, is it not?
No, it is based upon both. The administrative judge ruled that way, Your Honor. But
So what did the administrative judge find in terms of the truthfulness about the petitioner's statements about what occurred in both matters?
what about petitioner statements, Your Honor?
What what was the outlook, what was the administrative law judge's outlook as to whether he had received truthful statements from the petitioner about both incidents?
Your Honor, there was no need to write this up. We're talking about number one now for.
Yeah, but he's interviewed about both things afterwards, is he not?
Yes,
Was what he had to say about both matters truthful? The Clark matter, doesn't the videotape contradict what the petitioner had to say about it?
what tape are we talking about, Your Honor?
Isn't there a videotape
Yeah,
showing this?
there's a videotape, and let me tell you about the videotape very quickly.
Well, you know what? You can get that on rebuttal, on that 1 minute rebuttal. Thank you.
Can I, Your Honor? Or-
Well, we got it. Just, I'll give you time on rebuttal. You just think about that,
Okay,
right? I gave you more than 5 minutes.
Good afternoon, Your Honors. Josh Liebman for the respondents. Paul's firing does not shock the conscience, does not approach shocking the conscience for the reasons we've described, and that's the only issue that the petitioner chose to argue in brief to this court. I just want to correct some mischaracterizations that my colleague made about the record. There was a directive setting forth plainly the requirements to retrieve property from the property clerk's office. It's Directive 2307. The ALJ's underlying decision discussed it with cites to the hearing record at page 447 of the record. That directive set forth, as the court pointed out, the various things that Paul was supposed to do and admittedly failed entirely to do to document and otherwise properly make this delivery.
Ultimately, though, he had a hearing. This is based, we're now on a substantial evidence issue, correct? I mean, it's
Well-
whether or not the findings below was based on substantial evidence, right?
That's correct. We
And-
originally
and in
are here
response
on
to
a...
Justice Friedman's question, the hearing officer made credibility findings.
Correct.
I believe, right?
Not only did the hearing officer make credibility findings, i.e. that Paul testified unreliably and lied throughout the hearing and in his interviews prior to the hearing, Paul himself has admitted, including in his brief to this court, having done the underlying things for which that he was found to have done. For example, he doesn't contest that he made the delivery. He doesn't contest and admitted at the hearing that he didn't report the delivery. He also admitted he didn't file a report when the inmate passed away, nor does he contest that he's the officer seen on the videos of the chokehold incident engaged in the scuffle with the inmate.
Well, he didn't even say that. He described it as not a chokehold until he was presented with the video.
Correct, but as you point out, the ALJ was well within her rights to find that his testimony was self-serving and incredible, and that all of the litany of other witnesses who said the video showed exactly that were credible, and that suffices to dispose of this case. I would add, too, as we point out in our brief, even one of the laundry list of violations that Paul committed would have more than amply warranted his disciplinary termination. These are incredibly serious instances, both of them independently, particularly in the context of a place like Rikers Island. So assessing Paul's conduct in its totality,
The
it warrants
standard by which we review this is not what we would do, but whether what's taken place at the administrative level was rational.
That's absolutely right. The shocks the conscience standard, as this court is aware, is incredibly stringent. Even if this court happened to disagree with the discipline imposed, which I submit that it should not, this court nonetheless must confirm it unless it is so beyond the realm of reason as to shock the conscience. And the numerous cases we've cited in our brief make plain that this case does not come close.
And just going back to the choking incident, now, Paul did file a false report.
That's exactly right. Paul filed a report falsely omitting that he had placed the inmate in handcuffs, and more to the point that he had, for at least 14 seconds minimum, as shown on the video, used a prohibited chokehold.
And just with the 14 seconds, because there was also a testimony that the inmate didn't pose a threat, and I believe there was some evidence that he was encouraged to stop, but he continued to impede on the
That's
inmate?
precisely right. Shortly after Paul began using the chokehold, the inmate screamed out, "I can't breathe." And in addition, another officer standing right next to them, who was also participating in this encounter, yelled out repeatedly to Captain Paul in an effort to get him to release the inmate's neck. Nonetheless, for at least another 8 or so seconds, he didn't do so. Instead, he squeezed on the inmate's neck for that period of time.
Thank you.
may I respond?
Relax. Thank you. Thank you very much. So I will give you 3 minutes because he finished early to respond.
Thank you very much. As far as the choking incident is concerned, I ask each and every jurist to look at the videotape There were
Well,
three
yeah,
people.
we have.
Three people around this inmate. For the first 6 or 7 minutes, he is turning and twisting. All they're doing is holding his arms. Paul comes, they hold his arms. No one touched him. This went on for another 3 or 4 minutes. He dragged all three down. Counsel's brief says that they threw him to the floor. He threw them to the floor. You can't miss it by looking at the videotape. At that point, Paul comes in. Paul had his hand around his arm, and then he lays on the guy. Paul weighs 230 pounds.
Counsel,
I'm
you
so
know,
glad you brought that up about the video, because I want to go back to that. Because the bottom line, we saw it, and even though he was confronted with the video, he still said, it wasn't me, I didn't do it, right? He denied it.
No,
I'm paraphrasing
He
him.
didn't deny it. He said he was just acting
but
accordingly.
counsel, we're not as where we sit here. We're not reviewing.
I know,
the evidence,
Judge.
on the original instance. We have to see whether or not the hearing officer, the LJ, went beyond went outside of the scope of his authority here, and it's a substantial. Correct me if I'm wrong, but it's a substantial evidence issue that we have before us, and also. The ALJ or the hearing officer made credibility findings too. It takes a lot, and you know this, for us to to toss all that out, right?
But Judge, one of the findings the hearing officer made was that had he reported, had he done things the right way, and there was no right way, there was no code, they would have known about what the shorts contained.
Well, as a 14-year,
fentanyl.
as a 14-year veteran of the force, I mean, he had an opportunity before the hearing to make those arguments before the hearing officer, and that's why the hearing officers wrote what they wrote, because he didn't put forward those things.
It doesn't comport with the facts. He had no business. There was no duty on his part to do any of the things the hearing officer said. Look, the hearing officer had the video showing Paul giving the inmate the underwear. The inmate then tore it up and gave him the bag back. They had that. It took them 17 months in order to do anything. They never charged him. They had all this. The DA examined this case. And what I wanted to tell the court, the DA and the intelligence department examined the case and wrote to the commissioner that Paul had nothing to do with this incident.
Got it.
Nothing.
Thank you.
That's why I'm here, Judge.
Thank you very much.
Judge, thank you for your time. I appreciate it.
RCI Hospitality versus White. Okay.
Thank you. Ethan Cobry of Schwartz, Ladkus, Reich, Greenberg, Atlas. Good afternoon, and may it please the court. This court has time and again held that a defamation plaintiff who wants to escape the absolute bar and privilege of Civil Rights Law 74 can't just say sham. The defamation plaintiff needs to make a specific and detailed factual showing, or even maybe point to evidence supporting the narrow sham exception.
Well, hasn't the Williams exception sort of evolved a little bit? That it's no longer reputational harm, but it has to also do with some sort of coerciveness and other issues, other, not so nice issues. I mean, the Williams exception sort of was stated first in terms of reputation, right? But then subsequent cases have changed that a little bit.
It has become broader, Your Honor.
Well, you haven't, and you didn't cite the Gottwald case, which was a big case that went up, right?
That's true. I didn't cite that, but it doesn't change the analysis on a Williams exception, because at the end of the day, this court holds time and again that if you want to escape the bar, which is absolute of Williams, you need to put in detailed factual allegations or even evidence. So that's what this court held in 2022 in Whedon versus Lukasik. Quote, in the absence of alleged facts supporting the Williams exception, the privilege under Civil Rights Law 74 is absolute. Justice Oing, Justice Kennedy, and Justice Friedman, I believe you were on the panel in that case.
Yeah, but I think
Similarly,
I
If
think
Von-
Gottwald really did a lot because Gottwald was just not only reputational harm, but there was also added factors about there's a contract that they sought to one of the parties sought to get out from under. There was this pressure. There was commercial gain. There was a whole host of stuff involved.
But you
in
still
that
need to,
case.
but you still need to allege all of that, and RCI here hasn't alleged any of it. Their complaint actually says nothing to establish that this action by Mr. White was a sham. The trial court, in its order, identified absolutely nothing, and even on appeal, we challenged RCI to come forward and say, show us the facts that establish that Mr. White's action was a sham. And on page 29 of their brief, they say there's ample evidence, but they point to nothing. In fact, Mr. White's action continues to be hotly litigated to this day, 4 years later. How could that be a sham action? Mr. White has engaged...
You know, unless I'm reading, correct me if I'm wrong, but I thought the RCI complaint has in their defamatory statements made by defendant here to press falsely, to the press falsely alleging illegal conduct by RCI in their businesses for the purpose of evading payment for his activities at the clubs. That's kind of...
And then it goes on to detail the night very specifically as to what happened when he went to different clubs, who he went with, how he paid the money, he gave tips in addition to the amount that he was charged. I mean,
But the case law that we've cited, binding and controlling case law, says you don't get to impugn the case itself. And whether the plaintiff in the underlying case ultimately succeeds is irrelevant. The only question is...
I'm not disagreeing. It would have been helpful to have the Gottwald analysis.
when the court decided this case, that decision by the Court of Appeals hadn't been issued yet. So we have it now. Doesn't that change your position a bit?
It doesn't, because you still need to put in the detailed factual allegations to show that the case is a sham. Gottwald didn't change the analysis from moving it from whether the case is a sham.
Okay, let's say I buy that. You don't think that the allegation that I just stated is sufficient to get to at least a sham type of situation?
No, on the contrary, Justice Owing, because if you look at the complaint, in paragraph 9, for instance, they say defendant's false statements were made to deny a fact of which he felt ashamed. Maybe, but that's not solely to defame, and that's Williams. In paragraph 10 of their complaint, they allege it was done to obtain, quote, offers of compensation and monetary concessions. But again, that's not solely to defame. In paragraph 51, this is the last one.
Okay, I was going to say, keep going.
I see
You're
the light.
eat for 3 minutes.
I see the light. In paragraph 51, they allege affirmatively defendant's statement to the New York Post was in the name of commercial gain. Again, that's not Williams. Even under Gottwald, that's not Williams.
All right, thank you. Thank you.
Jeffrey Kimmel, representing respondent from Ackerman LLP. May it please the court, I'm glad that the court today has brought up the Gottwald case, because obviously that is a controlling case now based on the Court of Appeals decision.
What Williams said one way has sort of morphed and sort of evolved to today. That it's just not reputational harm, but there could be other reasons for someone to do what they do in terms of going to the press and then, filing a lawsuit and then going to the press, or the other way around, however you want to do it.
That's correct, Your Honor. And what the Gottwald court said was all of these cases that were decided after Williams, that narrowed Williams to the very specific facts of that case, are essentially abrogated, and that Williams is not limited to solely...
The attack upon your case seems to be that you do not have specific enough allegations. What are the specific allegations that you've made which you say suffices under Williams and under Gottwald?
Thank you, Your Honor. So the complaint itself very clearly lays out exactly what happened that night, and then the statements made by Mr. White, and then the claims made in the lawsuit. And what, on page 11, I'm sorry, paragraph 11 of the complaint, respondent alleges the action, referring to the White action, was commenced solely to bolster his false accusations to the press. In paragraph 46 of the RCI complaint, RCI alleges, respondent alleges, that if the complaint, referring to the more detailed complaint that had not yet been filed, if a complaint is filed with these allegations, referring to the false allegations made by White, it is false without merit, designed to embarrass, humiliate, and/or harass plaintiffs, and/or extract monetary concessions. Now, appellant's position seems to be that if at any point in the complaint it's alleged that Mr. White also has seeking some sort of monetary gain from his actions, that it can't also be malice, that it can't be malice to fall under the Williams and Gottwald purview. That's not the case. It's alternative pleading. This court has recognized many times you can plead in the alternative. Over and over again, the RCI complaint refers to the defamatory tactics of Mr. White and the false accusations made by Mr. White intended to embarrass and impute the integrity of RCI, of the respondent. It's said over and over again. And what's more is that in the court below, and while it's not an issue on appeal, Mr. White moved to dismiss the RCI complaint under 3211G. Under 3211G, evidence was submitted to the court about the underlying case and the defamatory statements, and the court found, based on the evidence submitted, that there was more than enough to suggest that Mr. White's statements were defamatory and untrue. Therefore, the action falls under the Williams and Gottwald exception.
Okay, thank you.
I think what we may be missing here is you still, no matter how Gottwald expanded Williams, perhaps, you still need to show that the litigation is a sham. And the allegations that my friend just read to the court from the complaint, all that, those are conclusory. So for instance, if you take a look at page 26 of the record, that is an email from the New York Post to me reaching out and introducing the reporter, introducing herself to me saying, would your client like to give a comment on this litigation? How could Mr. White have brought this action to defame or for any press-related reason? He wouldn't know. This is unlike Williams. In Williams, the defendant, the defamation defendant, affirmatively circulated press releases. Mr. White could not possibly have known that the New York Post would reach out to his lawyer and solicit comment. That alone undercuts any application of Williams here. As far as the trial court's treatment of Mr. White's underlying litigations, I would just read to the court from its own decision in Peters versus Koutsadontis. Justice Oying, I think you were on the panel there, quote, his failure to prevail on the underlying litigation does not vitiate the privilege, since if the privilege existed only in cases that were ultimately sustained, none of the persons whose candor is protected by the rule would feel free to express themselves. And at the end of the day, they've never responded to this simple policy argument. If all you need to do to avoid and strip away the protections of Civil Rights Law 74, if all you need to do is say sham and include some boilerplate accusations in your complaint saying it was done for this, and alternatively it was done for that, and there are no facts. And if that were enough, then every defamation plaintiff could always get around the bar of Civil Rights Law 74, because in every case, the defamation plaintiff would simply say sham. The Williams exception would end up swallowing the rule, and Civil Rights Law 74 becomes absolutely conclusory. It's irrelevant, and I'm sorry, illusory. It would become absolutely irrelevant. They've done nothing more than that in their complaint, zero. And in fact, their own allegations undercut a sham exception. Page 26 of the record on appeal undercuts any application of the sham exception. So we respectfully request that the trial court's order be modified accordingly to dismiss the defamation claim.
Okay, thank you.
Thank you.
Kuhn versus WFP Towers. Right there. Don't worry, Brian doesn't bite.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant respondent. Let me tell you what I want you to do first and then give you my argument as quickly as I can. I'd like you to grant me summary judgment on my cause of action under 241-6 based on 12 NYCRR 23-1.7E1. I want you to sustain.
That's the passageway, Greg.
Don't the pictures themselves call into question whether or not this is in fact a passageway?
The answer is no, for the very simple reason, and we cited it in our brief time and time again with the page references, that Donnelly's testimony was that he took representative photographs of myriad of holes. Now remember, Donnelly also testified the holes were there, and there were about 50 of them.
Do we know why those holes were there?
I'm sorry?
Do we know why those holes were there on the 9th floor?
We know that this is what we know about the square holes. This is the hole that plaintiff fell in.
They're relatively small holes, whether they're 4 inches by 4 or 5 inches or 3, right.
So what we know, this is what we know. We know that they had really no use in this construction project because at the end of the project, I think it's 1619 and 1720, they were filled in with concrete. And the all-ran witness,
So you mean
Mr.
these
Saunders,
holes weren't created for this job?
in my opinion, absolutely not. In fact, the witness, all-ran's witness said, we don't use square holes.
Right,
We only have round holes.
Right. That was the point I was going to make, that was specifically the scope of their job was round holes.
Correct.
And that nobody really had anything to say about the square holes in terms of their purpose.
I'm sorry, I didn't mean to cut you off, Your Honor. Saunders had a lot to say about it. He said...
No, but I meant in the context of it being needed for the job.
Correct. That's absolutely correct. Saunders said...
So therefore, just taking the next step, it would be your basis to contend that Turner should be on the hook for premises conditions.
100%. And I don't even base it on Donnelly's testimony, and I don't even base it on Saunders' testimony. How's about what Costello said? This is what Costello said. I have the page references for you. He said that even though he said that Turner wasn't the general contractor, that doesn't mean anything. I can say I'm an appellate division judge. I'm still Brian Isaac, just arguing cases. That doesn't mean anything. But here's what he did say. Turner had overall responsibility for the project, including hiring various subcontractors, 1097 to 1098. Turner was responsible for the coordination of trades and sequencing of work and had to assure compliance with drawings and specifications, 1095. Costello testified that Turner worked the site daily, 1104, hired security, 1138 to 1139, had site safety supervisors, 1098 to 1099, had weekly meetings with subcontractors where safety was discussed, 1121 to 1122, had the authority to stop unsafe work practices and unsafe conditions, 1101 to 1102, held safety meetings, and...
So that all goes to means and methods, does it not?
I'm sorry?
That all goes to means and methods.
Yes,
under Labor Law 200.
Correct.
Supreme Court dismissed the means and methods aspect of your claim.
Correct.
As to Turner.
That's right.
Turner remains in only under the position that it's a premises defect.
Well, Judge Friedman, you're right.
As to Labor Law 200.
Correct. Our position is that we win on premises defect based on the Velasquez decision and based on Pichardo against Urban Renaissance, because there's zero question here. There's not one single question of fact.
What's the rule as a general contractor is liability on the premises defect consistent with what we held in Capianca?
So the rule that has emerged in this department and the second department, actually both.
Capianca remains good law, does it not?
It does. But the rule is if you have knowledge of a defective condition, if you're a general contractor and have control over the site, inaction alone is not exculpatory, it's inculpatory. And I just want to point out to you...
But that doesn't mean means and methods. It means premises condition.
I'm responding to Judge Friedman's question. Judge Friedman asked me, he didn't talk to me about means and methods. I thought your question, Judge, was about premises.
Yes, means and methods is out of the case.
Unless you reverse,
Right.
which you...
Is there an issue with the notice that might have been?
Absolutely not. Here's why. Donnelly testified, and I don't see it being disputed anywhere, that when he got to the site, there were holes all over the place. That's why he took the photos. When you read his testimony, he said they were all over the place, and he didn't even know what floor they were on. He wasn't sure if it was on 8 or it was on 9. He said that those conditions never changed, and in fact, they still remained present even when the work was being done till the end when they were filled in. So my position is that if I check a site every day for a week, and there are holes all over the place, and I say I didn't see them, that's not exculpatory, that's inculpatory.
But that goes towards the premises, the defective condition,
Correct.
not the means and methods for which you would have supervisory control and things of that nature.
Your Honor, the truth is, if I win on any one, I don't care. I'm not particularly concerned how I do it. That's really the truth.
All right, thank you.
Okay.
Good afternoon, and may it please the court. My name is Michael Joseph. I'm an attorney with Cohen and Dykeman in our office.
So what is your view as to these holes in terms of the premises defect? Were these holes part of the job or not, or were they pre-existing?
So
Or is there a disputed issue of fact about that?
when Turner first arrived at the job site, Mr. Costello, their general foreman, testified that their only openings in the slab on the 9th floor were for the staircases. There were no other openings in the slab. The openings put in the slab after, were to access the electrical raceways, and they're typically known as floor boxes. And Mr. Costello testified that he witnessed Allran making square floor boxes,
But Allran says that they only made round holes. Isn't that a question of fact?
But in terms of the claims against Allran, no, because Allran was required to protect all of the openings. But in terms of
So is there a view that the holes were not, the hole within which caused the plaintiff's fall was not part of this job? Is there an issue as to that?
the hole, it was part of this job, was a floor box with access to an electrical raceway. Under Allran's contract, they were required to cover all accessible points to the electrical raceways, including all floor boxes. So yes, it would be part of this job. And in terms of the 241-6 claim in the passageway, as you pointed out, the photographs show that it's in an open area that's really surrounded on one side by cubicles and columns spaced 10 feet apart.
But does our case law support that when there is this dispute as to if it's a passageway or not, that's something that's best left to the trier of fact and not necessarily an issue of law?
As I'm sure you're all well aware, the interpretation of the industrial code is an issue of law fit for the appellate division to decide. However, depending on if there are facts that they believe they are that you're in need or they're missing from the record, then yes, it can be an issue of fact to that. But in this case, columns spaced 10 feet apart with a wall on the other side do not necessarily make a passageway when it's in the middle of an open area, which is something that plaintiff testified to. It's something that Mr. Costello testified to, saying that there were no partitions up, and plaintiff even testified that you could see all the way across to the other side where the Allran workers were working. So in terms of the 241-6 claim, this is not a passageway. 241-6 Industrial Code E1 does not apply, and plaintiff's attempt to resurrect his claims under E2 are equally erroneous because plaintiff admitted that dust, dirt, debris, or sharp projections had absolutely nothing to do with his claim. And with respect to the Labor Law 200 claims, as you noted, the means and methods claim has been dismissed. There's no liability under means and methods, yet this is still a means and methods case because these floor boxes were created in the slab. They're no different than the screw in Delana. They're no different than anything else that was installed into the floor. And consistently, this department has held those cases that are means and methods cases when the installations are the ones that cause the injury. And here, the floor box is what plaintiff alleges causes injury. So in that case, Labor Law 200 would be dismissed because there's no dangerous condition claim. It's a means and methods claim, and that claim and the trial court found no liability under means and methods. With respect to the notice issue under the dangerous premises condition claim, though, you're right in that there is an issue with that. They need notice of the specific condition. And
Would you agree that if the holes were not part of this job but were pre-existing, that it would create a premises defect?
there's no evidence from anyone with any probative knowledge that these holes were the floor boxes were pre-existing. The primary testimony relied upon is the testimony of the Bigman foreman, Joseph Donnelly, who did not arrive until 4 to 5 months after Allran had started work on the 9th floor. Conversely, Turner's witness, who was present the entire time, Larry Costello, testified that the only openings on the 9th floor slab were for the staircases, and that there were no floor boxes in the slab prior to that. And with respect to And with respect to those floor boxes, unless they know the specific floor box that induced the plaintiff's injury, it's not sufficient to just allege general awareness of a potential condition. These floor boxes were in use to run low voltage cables to provide power to the cubicles and office spaces. And I see my time is nearly elapsed.
Thank you.
Your Honor, I'm sorry. I don't think you can safely say that a hole in a construction site is not a dangerous premises condition based on your decision in Trinidad against Turner, McCulloch against Bryant, Thomas against Goldman Sachs, Piccione against Sweet, and Kaufman against Capital One, all of which said that, quote, inadequately protected gaps fall within the
Yeah, but the question is always who's responsible for it, right? I mean, yeah, let's say I agree with you that a hole in a construction site is, not a good idea. Who's responsible? You got everybody else.
I can give you an answer. Real simple. In a labor law case,
There's no such thing as real simple in labor law.
Fair enough.
I learned that much.
I stand corrected.
Okay.
Let me give you my answer, which I think is simple.
Okay.
Hopefully you'll think it's simple too. In a labor law case, based on Sanitas, based on Celestine, based on Coleman, status-based liable. If Turner is a responsible party, if Time, who's the lessee in possession, is clearly a responsible party, if there's any problem there, they're responsible for it. They get to get indemnity from the responsible party, but I don't think this is complicated. I certainly have done enough labor law cases to know they're incredibly complicated, but I think this Court of Appeals...
If there's something done on the premises which is necessary for the job, which is part of the job, that's not looked upon as a premises defect, that's looked upon as a means of method.
Well, the problem is that the way you're phrasing it is correct. You're smarter than I am, except I want to phrase it a different way. Okay? There's no question that something can be integral to the work, okay, but still create liability.
That's the phrase.
Right? And here's the case. The cases that we cited, there are two. They're from the second department. One is Murphy against 80 Pines. The other is Lopez against New York City Department of Education. Lopez was mine. What happened in Lopez was the plaintiff was impaled on a rebar through his rectum at a site. There was no question whatsoever, Your Honor, that the rebar had to be there because it was part of the superstructure. But it wasn't capped. So you can have something that has to be there, but if it's unprotected, it can't be integral to the work because it's by definition antithetical to the work. That's my point.
Here, the holes, the square holes that everyone seems to realize, well, not your friend probably, was not integral to the work.
My position, Judge Shulman, is it wasn't even part of the work. It had nothing to do with the work, as evidenced by the undisputed fact that at the end of the job, it was filled in with concrete. So how could it be part of the job? That's not disputed.
All right, thank you.
With respect to the parties that can be held liable under the labor law, WFP Retail and WFP Tower aren't two of them. They don't qualify as statutory defendants, and at no point in his brief or in his argument has he established that these two entities have anything more than a possessory interest in the site. So in respect to the appeal there, alone, that appeal should be that portion of the appeal should be denied, and therefore to no liability under 241-6, to the extent that they're still under the case under Industrial Code 23-1.7E1. With respect to, the argument that these holes are dangerous at site, they're not holes. They're floor boxes. They're used to run cable through electrical raceways to power the cubicles. And that's the exact low voltage work that several electrical contractors were hired to do at that site, including Allram. And as part of their work, when they were not using them, they were required to cover them. And they were required to place a cone in front of them. And that cone was present in front of plaintiff, and which is something that he testified to as he was pushing the cart after his incident. So in terms of, in terms of liability under labor law 241-6, the integral to the work defense would apply. The fact that they weren't filled in till the end of the project just means it wasn't clear whether or not those cells would be necessary to access the raceway based on where the furniture was placed at the time. Once the project is over and all the cables are laid, yes, you can fill in the holes that are not necessary and they don't have cables running through them, but until that occurs, you may need access and you may need to use the different holes to get access of power to the cubicles. So the integral to the work defense would be able to bar any liability as to the other defendants under Industrial Code 23-1.71. With respect to Labor Law 200, again, there's been nothing here to suggest anything other than general awareness of floor boxes on the 9th floor.
Okay, thank you. Invictus Global versus G Engine. Justice Friedman is recused from that matter. Okay.
Good afternoon, Your Honors. Invictus is an investment firm that invests in distressed debt, including the purchase of bankruptcy claims. The central purpose of the purchase of bankruptcy claims is for the purchaser.
Well, the question I have is, I think in my mind, the notice of defective transfer, did that trigger the disallowances in Section 5 to require or compel the defendant here to pay you back?
Yes, because the notice of defective transfer is a failure to substitute. Let me explain what the process is.
Well, yeah, you can say that, but ultimately the bankruptcy court said that the person that was the administrator shouldn't have done, Crow shouldn't have sent that notice out. They didn't have the authority to do that. I mean, that's the problem, right?
That's correct. That is the problem, except for the fact that the parties drafted the repayment provision as an express condition.
Correct.
And under the terms of an express condition, if the condition occurs and the repayment provision provides for immediate repayment upon the occurrence of the condition, the fact that the condition is subsequently removed does not negate the repayment obligation. And that is the CRG case. Judge Schulman, I believe, was on the panel for that. And Judge Owing, you were on the panel for TRC, which was the same.
I've been here too long. I've been being referred to constantly today.
Which, anyway, both those cases involved an express condition in which the condition occurred and then was subsequently removed, and the court held that the repayment provision is valid.
When you're looking at that provision, the disallowance provision,
yes, Judge.
and the sole, I think, the key point of your appeal here is the alleged inadequacy of the substitution. The actual language is assignee fails to be substituted for the assignor in respect to the claim.
Yes.
Now, in this case, Invictus bought the rejection damages claim, the G rejection damages claim, for about 60% of the value.
Right.
Correct?
Yes.
15 million, whatever. And ultimately, after reorganization, where they were on the list as unsecured creditors, they got 16 or 19%.
Right.
So they were substituted. They were on the list. You're hinging your appeal on the notion that maybe had they been on the list earlier rather than later, because it's delays, not failure to be on that list, that your client didn't have a say as to voting on the reorganization,
right,
which may have changed things. And again, to me, that's really speculative. But isn't that what you're holding?
Yes, well,
that's what you're holding your hat on.
Yes. Well, this is why I hang my hat on Judge Schulman. The failure to transfer is a failure to substitute. And what happens is my client is disenfranchised from rights immediately.
But that's not in the agreement.
Yeah,
voting isn't in the agreement.
No, but the point is, the reason why the provision was drafted as an express condition, which means as
yeah, we don't have an issue with the express condition.
Right.
It's the timeness, because when you're saying, as just succinctly pointed out by Justice Schulman, this is, you ultimately got the assignment, all right? There was ultimately, at the end of the day, a delay, but you got the assignment. And obviously, you didn't get what you wanted because the percentage was so low. But you're saying that, how is it then, when you talk about these voting rights and other things, I'm reading this provision here in the Section 5, and it doesn't talk about timeliness, about how 30 days, whenever we execute, that this transfer has to take effect, otherwise it's not. You had all these, protections or guardrails to put in place for this express condition. We're not here disputing about the express condition. We're just trying to figure out your argument that's saying, well, there's been a delay of this express condition from becoming satisfied, and this caused me harm, and I want my money back.
Okay, so it was not a delay. It was a failure to substitute. And if it was,
But didn't you get substitute at the end, though?
But when you have, we all
Yes or no?
acknowledge,
Did-
we all
no,
acknowledge
no,
there's an
that-
express
that's a
condition.
simple question.
What if the defective transfer notice said, notice of defective substitution? It's the same thing.
Doesn't say that.
Well, it says notice of defective transfer, right? So then you have to say that a transfer is different than a substitution. Let's take the example, if the terminology on the notice of defective transfer was notice of defective substitution, then there wouldn't be any question that that was a substitution failure, because in fact, GE had to go into court to get the substitution to occur. So a notice of defective transfer, it's semantics, it's distinction without a difference. I mean, you have to look at the context of the entire agreement. The entire agreement was for
The way I see it is that you know who the person here that messed this up was Kroll. I mean, they're the ones who issued the notice of defective transfer when they didn't have authority to do that.
That's correct, and that's
So maybe you're going after the wrong guy.
No, that's exactly why this provision was drafted as an express condition, because it doesn't matter whose fault it is. All that matters is that the condition occurs. It doesn't matter whose fault it is. And as soon as the condition occurs
Well, it doesn't occur. In this case, it doesn't. The condition doesn't because it fails to, you get failed to substitute, right? So it doesn't happen.
So
the question I have, and it's a very simple question, did you get substituted? Was there a substitution?
yes, there was a substitution.
Great.
Yes, there was a substitution, but in
Not the way you liked it. though.
no, well,
Not the way your
in
client wanted.
CRG, there was the claim wasn't listed on the schedules, and a proof of claim was filed, and the court said it doesn't matter.
I'm so glad you brought that up because I have the CRG and the TRC here. And there, the conditions took place. So of course, that's not what we have here.
No, the conditions didn't take place.
Right.
Or they-
Yeah,
Well, I guess,
different.
is a notice of defective transfer not a failure to
Let me
substitute?
ask you this question. So that notice, did it say that the transfers were defective? That notice of defective transfer, did it say the transfers are defective?
Correct, it did.
I don't think so.
Your Honor, most respectfully, it did.
Well, it's fine.
Okay.
He'll address it.
All right. Okay. Thank you. Give me 1 second.
Good afternoon, Your Honors, and may it please the court. My name is Tyler Domino, and I represent Respondent GE Engine. I'll start with the notices of defective transfer.
Please.
If you turn to the notices of defective transfer, which are at record 130 and 136, they don't say that the transfer was defective. What they say is that Invictus's notice of transfer was defective. Their notice of transfer was defective because they filed it under the wrong bankruptcy.
They forgot to dot an I and cross the T. That's essentially it. It's not
that's
so much
all
that they're
Kroll was
quibbling about the substantive part of the transfer. It's just like, you didn't give us the proper paper.
Exactly. That's exactly right.
Because we're going to be on the hook if we do the transfer and you didn't do it right.
That's absolutely correct. And at the end of the day, all of these bankruptcy procedural twists and turns
It's
are
a
irrelevant.
distraction. It's a distraction because at the and counsel did say the substitution did occur, and as Justice Shulman said, it didn't occur timely. It was let's just say timely. He's arguing that there was no delay. Let's just say it wasn't timely. But I'm reading this section 5, and there's no time element built into that. There's no guardrails.
That's exactly right. And if you look at all 5 of the disallowances, the other 4 each have a timeliness component to it. It's only Section E that doesn't. So we can't add one to it. The parties clearly knew that they could have added timeliness things to it, and they didn't. And so without that timeliness provision, the fact that the substitution occurred, which everyone agrees that it did occur, they got paid in their distribution.
And you
That's
know,
the
the
end of
whole
case.
point about the voting rights, and I understand about the voting rights, you want to be at the table, right? And they didn't get that opportunity because of the delay or the timeliness of the substitution. But if that were truly an important fact or important factor, that would have been in this condition here, right? I mean, something along the line, if this transfer or this substitution doesn't occur in time for me to exercise a vote, you pay me back.
That's exactly right. And if you look at the first paragraph of the contract, it talks about what the contract is about, and getting paid out on the distribution is listed there. Voting is not. The voting is a complete distraction.
Isn't this, the whole nature of this kind of transaction designed, it's a risk-benefit transaction, right?
That's exactly
I mean,
right. They're betting.
Even if there was a timely substitution, it's possible the reorganization plan would have allowed them only to collect 16% as opposed to what they initially bought it for.
Exactly right. I actually think that they collected way less than that. That's what was anticipated by the debtor earlier on. I think they only got a couple cents on the dollar at the end of the day. But that's exactly right. This contract is a bet on their behalf. They pay 60 cents. They're betting they're going to make that or more. And they lost that bet this time. It's not GE Engine's fault.
Man, I tell you, $10 million, $15 million unsecured claim. Okay.
If there are no further questions, I'll rest.
No, thank you.
So what I'd like to try to emphasize to the court is what is a notice of defective transfer? Because if a notice of defective transfer is in fact a failure to substitute, then perhaps I can persuade the court that the decision should.
Well, counsel, you can't say that you're trying to persuade us that the notice of defective transfer is a failure to substitute when ultimately there was a substitution. So that notice of a defective transfer is really, it doesn't do anything. It's not an obstacle. It may have been somewhat of an obstacle, but ultimately there was a substitution.
So if the notice of defective transfer stated, we are hereby not transferring or substituting Evictus as the holder of the claim for GE. And that's what the notice of defective transfer said. The fact that it was subsequently Evictus became the holder because GE went into court wouldn't matter, because you would have a clear notice of failure to substitute. And the notice of failure to substitute that comes afterwards, okay, would not negate the repayment obligation under TRC and CRG. So then the question becomes, what did the notice of defective transfer do? Was it really a notice of failure to substitute? And what the notice of defective transfer said was that Evictus will not be put on the bankruptcy claims register as the holder of the claim. That's what Kroll said. Kroll was appointed by the court. It was their job to substitute Evictus for GE. They didn't do it. They were supposed to do it.
Yeah, and
right.
and the bankruptcy court chided them for that too.
Correct, and GE had to go into court to get the substitution changed. So the notice of defective transfer was a notice of a failure to substitute. The fact that it subsequently happened does not change the outcome that Evictus is entitled to a repayment obligation because it is an express condition. So,
well, that's where you look into the language, and I'm always I always run to the language of the contracts to see exactly what this says, and what you're saying and what you're telling us to accept. It's just not there. I mean, that's something along the lines like, if there's a failure to substitute or a delay in the substitution or whatever happens, that it should be deemed a failure to substitute, therefore give me my money back.
But what GE could have done, and all the other, and Longacre versus ATS did it, is GE could have put in a cure provision. If there's a failure to substitute and that failure is not cured within 60 days, then the repayment obligation.
You mean Invictus could have put in that, right? I mean,
Sorry?
You mean Invictus could have put that?
No. If you look at Longacre versus ATS, which is a Second Circuit Court of Appeals case, the assignment of claim agreement is in the record. And in that assignment of claim agreement, there's a provision, I think it's involving an objection to claim, but it says if there's a claim objection, we get 180 days to resolve it, and the repayment trigger doesn't happen.
Yeah, but by the same token, on the flip side, you could have had, so your client could have had negotiated a portion of going the other way to protect them too, right?
But we didn't think we had. We didn't think we had to because it was drafted as an express condition.
Thank you. Thank you very much. Let's see, what's next? People versus Ricky Hayes. And Justice Pitt is recused from that matter. And let's wait for Justice Friedman to get back. Welcome back. Okay, we go.
May it please the court, my name's Elizabeth Vasily, and I represent appellant Mr. Ricky Hayes. Minutes before his guilty plea, The court told Mr. Hayes on his 15-count indictment, you need to decide whether you want to accept the court's offer or go to trial where you face a maximum of 25 on some of the counts and consecutive on a lot of the counts. That's up to you. And on a 15-count indictment, if a defendant hears that statement, they're absolutely thinking they're facing upwards of 100 years or some other multiple of 25 years to run consecutively. But the court's statement was incorrect. Mr. Hayes did not face 25 years on, quote, some of the counts. He faced 25 years on a single count. And Mr. Hayes did not face consecutive sentences on, quote, a lot of the counts. He only faced 3. And the sentence was capped at 50 years. All the court had to do in this case was say that, was to say your maximum sentence if you went to trial was 50 years, and the court did not do so. And this gap in sentencing exposure effectively communicated to Mr. Hayes this was a chance of a life sentence or not, of seeing outside a prison wall, or maybe having a chance that in the lower or middle range, if you took your chances at trial, you could get a lower sentence. But if the max is up in the hundreds, there's no sentence that would be in that range of doable for Mr. Hayes to be released. And this case is just like Joseph and other cases that panels of this court have similarly found that misstatements by the court at the time of the plea rendered the plea invalid. I'd briefly like to go to the excessive sentence point as well. In the case that this court should disagree with the plea withdrawal issue, 8 years is appropriate.
There's just one question I have. I'm looking at the minutes here, and correct me if I'm wrong, but the sentencing, page 30, the defendant stated that he was informed by counsel that if he proceeded to trial, you'll get 25 years on one and 25 years on the other. Did that happen, or am I looking at the wrong?
Mr. Hayes moved to withdraw his guilty plea at the sentencing. Is that what Your Honor is asking?
No, it says that sentence, so that must have been at the sentencing hearing, no?
I don't believe there's a page 30 in this sentence.
Oh, that's the post-plea proceedings, okay. I got it. That was post-plea. So you're arguing at the plea, during the plea, that they gave him the impression it was over 50 years that he was going to be getting, right?
Yes, exactly, Your Honor.
Got it, thank you.
And briefly, as to the excessive sentence point, if Your Honors have no other questions on the plea withdrawal, Mr. Hayes was having a mental breakdown during this time. He tried to check himself into the hospital the day before this incident to get his medications. He was unsuccessful. And for all of those reasons, we would ask that the court resentence Mr. Hayes to 8 years if there are no other questions.
Thank you.
Good afternoon, Your Honors. May it please the court. Robert Butlin for the people. The totality of circumstances here demonstrate that defendant's plea was knowing and voluntarily given. And the evidence shows that defendant understood, at the very least, that he was pleading guilty to a 15-year sentence with all of the underlying sentences running concurrently. Nothing the court said undermined that understanding. And in addition, the substance of
Actually, the people, if I understand them according to my notes, had recommended 18 years, correct?
The people were originally offering 18 years, that is correct.
The court dropped it down to 15.
The court never had actually, it seems like, was considering the 18-year offer. This plea offer of 15 years had been offered to defendant for over a year, so this wasn't exactly a rationally accepted plea offer. And again, Your Honor, contrary to defendant's assertions, the record is devoid of any evidence that the court's purported misstatements in any way influenced.
He had a particularly large amount of experience with the criminal justice system, isn't that so? I mean, am I right that he had 9 prior felonies in New Jersey?
Yes, Your Honor. I believe I have the number here. He had 10 felony convictions in New Jersey and 12 misdemeanor. And then he had 1 prior felony in New York as well as 3 prior misdemeanors. One of those misdemeanors was less than a year before this plea, and he also pled guilty in that case, which again just goes to the totality of circumstances that defendant at least had some familiarity with pleading guilty. He didn't have to understand the ins and outs of the criminal justice system. It is complex, but again, he understood the sentence that he ultimately pled to. And the court the record is just devoid of any evidence that anything the court said influenced his decision. And Justice Owing, you mentioned something during the sentencing minutes where defendant was saying that he part of the reason he wanted to withdraw his pleas because he was facing 25 years on some and 25 years on the other. But that 50-year aggregate is the actual aggregate that he was facing, which shows that he was understanding the maximum sentence he was facing.
But sentences, so what was happening at the plea, that is sort of indicative of he understood that it wasn't over 50, it was 50.
Precisely, Your Honor. Let me see. Okay, so unless Your Honors have any further questions about the plea voluntariness, if I could just briefly touch on the excessive sentence. Your Honors, it can be true, all of the mitigating circumstances that defendant cites, we don't contest, but the sentence was still fair in light of the crime that he committed. It was extremely shocking. It was a fight that lasted more than 5 minutes, which of course came after another robbery, and an 88-year-old woman was hospitalized for multiple days because of his actions. And I understand in our position we say a lot that the mitigating circumstances were expressly considered by the sentencing court and should favor not disturbing the sentence. But truly in this case, Justice Statzinger put great time and care into the sentence. This wasn't rashly done. Defendant didn't rashly plead guilty. Justice Statzinger didn't rashly give this sentence. He expressly said that he spent a lot of time thinking about this case, watched all the videos of the incidents, had considered defendant's mental health issues, and on and on. That's all in the plea minutes on pages 2 and 3. And of course, there was over 1.5 years of consideration for this. So unless Your Honors have any further questions, we ask that you affirm.
Thank you.
When Mr. Hayes moved to withdraw his plea, he didn't say that he faced an aggregate of 50 years. He said he felt coerced because he was facing 25 on one, 25 on the other. Trial was going to be a disaster. And instead, this shows that he was parroting back what the court said because Mr. Hayes didn't face 25 on 2 separate counts. He only faced 25 on a single count. So this shows he absorbed the court's misstatement. He felt pressure and coerced by the length of this sentence. And so that shows that he was precisely influenced in his guilty plea that way. Additionally, the fact that he had over 1 year shows that he was really struggling with this decision to take the plea, that he wanted to go to trial. And if anything, it could have been the court's statement. Right at the beginning, the court opens with, says, you have to decide. It's up to you. Do you want to take this plea or not? And that's when that court's coercive statement came in. So it shows that he was wrestling with this decision.
What is your reaction to the judge paying a compliment to defense counsel and persuading the court to give less than the 18 years? I mean, it's very rare that I've seen a situation where a court would compliment someone like yourself who's a zealous advocate, which I think the courts should do, I guess. But does that mean anything? That means the court really appreciated the representation, in fact, that defense counsel below was conferring with his client and grappling with it and making sure that his client would make an informed decision and not be coerced into taking the plea.
Absolutely. Lawyers are good advocates in different ways, Your Honor. Just because the trial attorney was great at negotiating and got his client a plea offer lower than what the prosecution was asking doesn't mean that he necessarily communicated the sentencing exposure to his client. Notably, the attorney didn't correct the record after the court statement. Nothing was discussed in the record that the attorney talked about the sentencing exposure with his client. So while maybe in some ways he was zealous, in other ways he clearly did not communicate this to his client. And Mr. Hayes, at his plea withdrawal motion, said that he didn't like his lawyer's representation. If there are no further...
Thank you very much. Hayco Properties versus 450 West 31st. Okay.
Good afternoon, Your Honors. May it please the Court, Jackie Aiello from Boyd Richards for the appellants. I would actually like to start with the 1999 litigation regarding, commenced by the plaintiff's predecessor, the Tai Chi Studio, which was a litigation in which that predecessor had asserted the very same claims against the co-op that now plaintiffs assert here. That litigation ended in a stipulation of discontinuance with prejudice being filed, as well as a general release being executed by that predecessor.
Yeah, but that doesn't bind the current physician or the surgical office here. You're not claiming that.
Absolutely, I am. So the general release provides that it binds successors, and the only opposition to this by plaintiffs is that this is a new claim, not a claim that falls within the general release. And I would say that cannot possibly be true because plaintiffs also in this case argue that there's res judicata effect by the preliminary injunction decision that was entered in that case, which would require that those claims be the same. That's the entire point of res judicata. So they can on one hand claim that they're the same to take advantage of the res judicata argument and then walk away from the release and say, no, they're not the same claims.
Is that where it ends then, or do we now turn to the lease and what was offered to?
Well, doesn't provisions, paragraph 7 or provision 7 of the lease clearly links to terrace?
I'm sorry, I
and
couldn't.
separate from the physical fact that the only way to access that terrace is through the surgical office's doors. I mean, it's really exclusive to the professional office that was purchased.
So a couple of things. I would say the double doors demonstrate nothing but access. It doesn't demonstrate that it's
Well,
an
nobody else
appurtenance.
can access it.
That's not true. And the plaintiff actually acknowledged in his deposition that, yes, you can, of course, go through the doors, but you can also access it by way of a ladder. And the co-op has done work in the past by way of the ladder to
That
do
doesn't
some work on the
indicate
skylight.
that you can access it by way of a ladder, doesn't indicate that you've got a right to use it. I mean, maybe you have an emergency or repair reason for going in, but it's not like having a door into the terrace.
What I would say is paragraph 7 provides exclusive use of either a roof to the penthouse unit, which of course this is not, or a terrace or a balcony that's appurtenant to a unit. And so since this is not a penthouse unit that we're talking about, plaintiff has to fall on the argument of this is a terrace. But if you're looking at common sense and the totality of the circumstances, there's no way the court can determine that this is a terrace, the boiler room roof is a terrace as opposed to a roof. This is an independent structure that has its own share allocation, and it functions as a roof. It holds up the boiler room. It protects it from the elements. It's a roof. I would also note that the lower court, although denied our motion, mentioned in the decision at least 15 times that this is a roof, not a terrace. And to find
a roof terrace.
No, the decision by the lower court, if you read it 15 times, he says a roof, not a roof terrace. Plaintiff calls it a roof terrace, but that is not what the lower court said in the decision, in the transcript. And I would also note that although we talked about access does not make it an appurtenance either. An appurtenance is a term of art which requires that space be necessary for the use and enjoyment of the unit.
So going back to that prior litigation, the litigation, they settled that case, right?
It was resolved, yes.
It was resolved.
Yes.
So there was never a judicial finding as to whether or not that roof or terrace or whatever was attached to that second floor.
No, however, there was a stipulation of discontinuance with prejudice, which is a determination on the merits, and the general release.
Whoa. Okay, when you say stipulation to discontinue with prejudice, that's to those parties there, but in terms of any findings, all you have is preliminary, the court granted a preliminary injunction enjoining the co-op from prohibiting from using that area, right? That's what that person won on that level, correct?
Yes.
So for them, when you say discontinue with prejudice,
it's the release, though, that bars these claims. And I would like to point to a case. It is this court's decision, 52 Riverside Realty. It's 119 AD 2D 452.
well, your release bars those claims. How can, I'm just trying to, maybe I'm missing something, but the release is between those two parties. It's between and somebody else, unless there's something in there that says that the successor to
It does.
there's in the release.
Absolutely, it does. And it says it at 245, it's 245 of the record. It says that it specifically binds successors. And that's why I would point to 52 Riverside Realty, although it doesn't have to do with a release. It does talk about how it's well recognized in the state that a transfer.
So does the stipulation say that the rooftop terrace is no longer attached to the second floor? They don't have access or use to it?
I'm sorry, say it again?
So the stipulation of discontinuance, or however they settle, how did they settle this case? I mean, I don't have that, unless I missed it. Is there the settlement in the record here?
No, there's no settlement
We
agreement.
don't know what they said.
No. There was no settlement agreement. There is an agreement between the parties. It's page 237 of the record. It was what was supposed to be an amendment to the lease. I'm not going to argue that it was a correct amendment to the lease. It was not. But I would also submit that it is an agreement between Tai Chi Studio and the co-op that is enforceable, and again, binding on successors. Because
Let me just ask this question, just in terms of the actions of the co-op. Were there communications to plaintiff that they needed to suspend, release all of their entitlement or access to the roof terrace and pay a licensing fee of $600,000? Like, how should we interpret that into your particular argument?
Sure. I mean, that is if we're going past the issue of whether plaintiff had exclusive.
Well, let's go past that.
So let's assume that you find that that he either had exclusive use or there's a question of fact. In terms of them asking about the license agreement, what I would say is there were, I believe that was in response to plaintiff wanting to put the HVAC system on the side of the building, which he's not arguing he has exclusive use to. So it would be completely appropriate to ask for a licensing agreement.
But just piggybacking off on what you said in terms of the lower court never using the word roof terrace, or what your own client used that in their emails, right?
That they use the word roof terrace?
Roof terrace.
As a layperson, if they use the word roof terrace, I wouldn't say that that's demonstrative of anything. And you have to look at what the building is. It's an independent structure that has a roof on top of it that functions as a roof. It has a skylight. There's nothing that indicative of that space being a terrace as opposed to a roof, as everyone is aware of what a roof is.
That letter didn't come from an attorney? That April 17th letter didn't come from an attorney? It came from a layperson?
I'm sorry, I thought you had said an email from the board. I may have misheard you.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is David Berkey of Gallat, Dreyer & Berkey, representing the plaintiff's respondents.
Well, she's arguing. She's arguing that that discontinuing for prejudice, it binds your client and so forth and so forth. And I'm trying to get.
Your Honor,
I'm
page
trying to remember.
245.
I'm sorry.
Page 245 of the record is where the stipulation of discontinuance is printed. It doesn't change the decision that Judge Weisberg made. It just says this action is now discontinued with prejudice.
Right, because I don't know what happened. I mean, there's nothing here that, in terms of how they resolved this issue about the roof terrace. What happened?
They gave up fighting, and I'm assuming, and I don't know, that they paid the on company money, and the on company entered into an agreement later to transfer its apartment to the next owner, not to my client, to the next owner, which would have been its immediate successor.
Counsel, can you address paragraphs 1 and 7? Because it seems to me that there's conflicting language. One paragraph, I believe it's one, right?
So let's
Exclusive
talk.
use of a unit, and I'm almost done. And then paragraph 7 talks about units. So can we address that conflict?
Yes, Justice Kennedy, the beginning page of the lease, which I believe is on page, let's see, 140 of the record, defines what a unit is. And it says that the unit contains everything in the walls that identify the unit, and then the appurtenances, fixtures, and any closets, terraces, balconies, roof, or portion thereof outside of those partitioned rooms. So it can be, from the exact language of the lease, that if you have a unit and right next to it, outside the four walls, there is a terrace, which happens here, and you have double doors going out to the terrace, and you supply the terrace with electricity, and you supply it with alarm service, and your predecessors have all used it, except maybe the immediate predecessor. We'll get to that in a moment. This is your exclusive use, which is what paragraph 7 says. Paragraph 7 says, if you have a terrace, which is defined by the preamble, then you have exclusive use of it. And it can be that you have a terrace, or if you're a penthouse, that you have a portion of a roof. And I want to get to this language dispute about roof and terrace.
Well, didn't the sponsor, wasn't there testimony where the sponsor himself said that the roof terrace was always intended to be part of the second floor unit, and he arranged for the installation of the door? This is record 407, 408. And the sponsor even focused on the fact that he put in language in paragraph 7 of the proprietary lease that I mentioned to your friend, which drafted with the understanding that the roof terrace was part of the second floor unit.
That's exactly correct. The sponsor said so, and he created the documents. And the president of the co-op in the earlier case said the same thing. The president of the co-op said it was always my understanding. That's Mr. Levine. Always my understanding that Unit 2 came with that roof terrace. That's next to it. You know, the only fault I have for Judge Leibowitz is he could have applied collateral estoppel, and he could have said the co-op and Ms. Atta moved before Judge Weisberg for dismissal of the complaint based upon the proprietary lease and the offering plan documents. And I'm denying that motion because the documents don't say what the co-op and Ms. Atta claim that they say. So he could have used collateral estoppel, but he didn't. He did his own investigation, and he came up with the same finding based upon the history, based upon the structure of the unit, the double doors, the electricity, the fire alarm that are supplied by our client's unit, and because of the prior use.
But also what's interesting here is that they made exceptions for other unit holders in the building.
Well, you know what? Let's talk about Unit 10, okay? Because Unit 10 is another unit with exactly the same initial share allocation as Unit 2. And Unit 10 has a roof terrace. It's the portion of the space outside Unit 10 that is the roof over Unit 9. And there's no T in the offering plan saying there's a terrace for Unit 10, just like there's no T in the offering plan saying there's a terrace for Unit 2, but they have the same share allocation. They should be treated the same way. They've always been acknowledged as having a terrace.
Counsel, one final point. Ms. Atta, who's on the board, she is the proprietary lessee of the boiler room that doesn't want the HVAC system over her roof.
That's correct. And she did everything in her power to tell the architects, to tell the board members and everyone else, don't let him use that roof terrace.
But I thought she recused herself.
No, and Ms. Green, who was deposed on behalf of the board, said, I don't recall her ever recusing herself. She actually came and she voted at board meetings.
Thank you.
Thank you, Your Honor.
I would like to address a couple of things. The first is this discussion and belief that the schedule of units that have the share allocation and the square footage for all the units, that somehow it's indicative of the fact that 2 is treated the same as 10 and 12, and so, meaning the square footage and the share allocation matches each other, and so they must all have must all have outdoor space. However, council ignores the fact that 1, 7, 8, 9, and 11 also have the same share allocation and the same square footage in the schedule of units, and they indisputably do not have any outdoor space. So we can't rely on the schedule of units either way. It doesn't move the ball either way. The sponsor did not consider what units do or do not have outdoor space, exclusive use of outdoor space, when drafting the schedule of units. So the reliance on that is completely misplaced. I will also point to the fact that when talking about paragraph 1 of the lease, council read a provision but left out a very important part of the language, which changes everything. Council read, the demise premises, the definition. And he talks about the appurtenance and fixtures and closets and terraces, but he forgot to mention that it's any that are allocated exclusively to the occupant of the apartment. It has to be allocated exclusively, and that was never done. For 2, it was done for 12. The sponsor knew what he was doing, and this is one of my final points, is the sponsor knew what he was doing with the offering plan. He knew how to allocate this exclusive use
But you
to
have
12.
but you have the sponsor's own testimony, I think, in here saying about what he wanted to do for 2.
Sure. So what he tried to do almost 20 years later was change the offering plan when he had done about 8 amendments to the offering plan. He knew how to allocate space because he did it for 12 and the roof for 12, and then 20 years later decides to amend the offering plan.
But that's like Justice Kennedy pointed out. You have like 2 conflicting provisions in that, the 2 paragraphs that she mentioned, units, plural. I mean, it's not. It's not an example of clear writing, let's put it that way.
What I would say is plaintiffs in their opposition, they say that the governing documents have to be construed against the drafter. And then they try to say that it should be construed against the co-op. The sponsor drafted it. So to the extent the sponsor then puts in an affidavit that wholly contradicts the governing documents, trying to, I guess, walk back on what he has in the offering plan, it has to be construed against him and not against the co-op.
Counsel, if I may, I want to go back to Board Member Atta because Counsel certainly mentioned it. Now, there's no dispute that she voiced her displeasure, objection, to the proposed alterations. My question is, was there any evidence of her recusing herself? Because it's clear she was at board meetings, but do we have any evidence that she recused herself from the discussions?
So the board minutes do not say one way or the other. She testified that she recused herself, and then the testimony that counsel spoke of did not say she didn't recuse herself. The question was, did anyone ask her to recuse herself? And she said no. However, if you look at Ms. Atta's testimony, she said, I offered to recuse myself. So those answers are not inconsistent. I would also say on the issue of individual liability, there is nothing in the record that would even suggest she did anything to persuade the other board members, and the lower court used his own conjecture and surmise to determine that there may be something that could come out in trial, and he even said, you know what, I think other board members likely didn't care about plaintiff's use of the space.
I'm glad you brought that up, and I'll be so quick because it's clear we all know about Ms. Atta, but for whatever reason, we couldn't recall the names of the others who supposedly objected. Is that correct?
Yes, she couldn't remember the names of them, but she did state that there was more than 3 that she could recall. She just could not recall the names at the time.
Well, we could recall board member Atta, right?
I believe so.
Okay, thank you.
Thank you.
Thank you.
Ibu versus Devon Stallings. Okay.
Good afternoon. Benjamin Rutkin-Becker on behalf of Devon Stallings. The prosecutor's reference to Mr. Stallings' pretrial incarceration violated his right to a fair trial and requires reversal of his convictions. There is no question that the prosecutor's conduct was improper, and under the circumstances of this case, a mistrial was required.
That was during cross-examination that happened?
That's correct, Your Honor.
And didn't the court issue an immediate curative charge?
The court did issue a curative charge. Your Honor, the court instructed the jury to disregard the comment, and this was simply not a comment that could just be disregarded.
Let's go further, shall we? Because I was under the impression that the court also invited defense counsel, to say something else, and declined that. Is that true?
That is true, Your Honor. Counsel.
Because he said something to the effect, by saying something, you highlight that fact. So, had an opportunity to do so and declined.
That's right. That's exactly what happened, Your Honor. And in this case, counsel was correct. It was his prerogative to ask for the relief that he saw fit. And in this case, under the particular circumstances here, a mistrial was the only proper relief.
Well, counsel, just based upon our case law, where there is a curative instruction, something saying disregard, that is sufficient. Why is your case different from that particular ruling?
Sure, Your Honor, and I acknowledge that there are many cases like that. There are also some cases as recently as March of this year in the Keith Woody case where this court has found that errors are prejudicial enough that they can't be cured by limited instructions, and that this is one of these cases. So I'd like, by reference to the error itself, as well as contextualizing the error. So first, looking to the error itself.
Why is eliciting that the defendant was in jail not curable? I mean, there was no bad faith by the DA here. You're not alleging that there was any bad faith by the DA in posing this question about the defendant being in jail. And probably the reason why the DA thought of asking it was to put in question the credibility of Douglas. If you knew that you were the one who committed the crime, why didn't you come to the authorities while the defendant is sitting in jail?
Right. So I don't want to quibble. I don't know whether I would use the term bad faith, but we certainly argue that the prosecutor's conduct here was willful, intentional, and it was blatant, and that is an appropriate factor for this court to consider. Your Honor, I think is getting at case law that generally allows for the prosecution to try to cross-examine a witness with exculpatory evidence on whether or not they came forward. But the prosecutor fully...
That's exactly what I was getting to.
Correct, Your Honor. And the prosecutor, that case law was inapplicable. One, the Jenkins case, that's a Court of Appeals case, relates that specifically is applicable in the context of alibi witnesses. The prosecutor had already successfully precluded this witness from testifying as an alibi witness. But more importantly, the prosecutor had already gone there. And the witness stated that, in fact, he had spoken for years with defense counsel about this. And so the first case that allows this type of testimony is the Dawson case. That's a 1980 case from the Court of Appeals. And there, the court specifically says, it cautions that prosecutors have to be careful about fair trial rights of defendants, and prosecutors have to be particularly careful when they're eliciting what has been shared with defense counsel and the fact that it may well be defense counsel who has instructed a witness not to go forward. So this prosecutor was engaging in the very form of the cross-examination that is proper to some extent, and the witness answered satisfactorily. And at that point, it's extremely prejudicial for the prosecutor to then intentionally elicit the fact of pretrial incarceration. This is an error that courts across the state for many years have held in plain terms undermines the presumption of innocence. There was absolutely no valid reason for the prosecutor to do that here. And
Counsel, if I may, I'll let you finish your sentence because I have a question.
that's fine, Your Honor.
No, finish your sentence, please.
There was no reason for the prosecutor to do that here, and this is in the context of an otherwise pretty straightforward case where there's not much evidence. This had a major effect.
What do you mean there wasn't? Are you talking about the weight of the evidence now?
That's where I wanted to get to.
No, Your Honor, what I'm saying is there's a difference in a case where, for example, perhaps there's other Molyneux or Sandoval evidence, or there's a
So
lot.
now I'm gonna briefly cut in now because I want to know, how is this against the weight of the evidence when the victim knew the defendant for over a year and stood next to him and observed the defendant shoot him? How is that against the weight of the evidence?
We point to several inconsistencies in our brief in his testimony. He was also a witness who had to be dragged to court. He did not want to participate. At one point, he had given an entirely different narrative at the hospital. And on the other hand, you have the defense witnesses' testimony that Mr. Stallings was not at the scene, though I will rest on my briefing as to the weight. I see my light is on, and I would like to touch on the sentence briefly in rebuttal.
You can do that on rebuttal. Thank you.
Thank you.
Counsel, after you identify yourself, perhaps you can address whether or not the victim ever wavered in his testimony provided conflicting testimony that he observed the defendant shoot him while he was standing next to him.
Yes, sir. May it please the court, Charles Wan for the respondent. Your Honor, the victim consistently identified defendant as the shooter. Shortly after the shooting, he made his way to his home and he told his mom that it was the defendant who was the shooter. And that night at the hospital, he told the detective, although it was identified the suspect by the nickname, but it was the nickname that the defendant was known by. And a grand jury and a trial, the witness consistently identified defendant as the culprit.
And there's also video evidence, and the video evidence doesn't actually show the defendant shooting Murray, right? It shows a muzzle blast, and the shooting takes place on the other side of the street, right? So, and you cannot make out the face of the person who did the shooting. But does that video evidence, which is quite lengthy, the video is quite lengthy, does that show the defendant hanging out at that corner?
It does not show the defendant, but it does show the shooter basically standing, I believe, just only about a couple of feet away from the victim. And there's no one standing in between them. There's nothing blocking the victim's view of the defendant for him to know who it was that actually shot him. And as to the mistrial motion, the trial court exercised sound discretion in deciding that this was an isolated incident and that the jury, and so it was suffice to just instruct the jury to disregard the testimony, especially since the jury is presumed to have followed the court's instructions.
How can, I mean, we know the prejudice that comes from hearing that someone is incarcerated, right? You think that they've done something wrong. How can you ever cure something like that by just telling them to disregard it?
Well, the courts have always constantly held that the jury is presumed to follow the court's instructions. And here the court instructed the jury right away that they're supposed to disregard it. And the issue was never brought up again. The prosecutor
How
didn't bring
much
it up.
longer was the cross-examination? Did it stop right there, or there was still sufficient time elapsing since that comment during the cross-examination?
As soon as the question was asked and the witness answered it, defense counsel objected right away.
Right.
And the court stated right away that told the jury.
Right. And did they continue the cross-examination?
I believe the cross-examination continued, but the issue was never brought up again.
Right. It wasn't as if that was what was ended. In other words, that was not the last thing the jury was left in their mind to hear.
Correct, Your Honor. Defense counsel wanted a break, but the court had it said we'll discuss it later on. So the cross-examination continued and heard further testimony, and the discussion was held later on afterwards.
And how does that additional cross-examination go to sort of affect the argument that it was prejudicial to the point where should have been a mistrial?
I think it actually shows that, as Your Honor pointed out, it was not the last thing the jury heard. Even if it was, the jury was told to disregard it, but there was further testimony, and I think that the court basically decided that instructing the jury to disregard is sufficient. I think was to show to the jury that this is not that important. You're to disregard it, follow the court's instructions, and basically pay attention to the rest of the testimony. And so it should not have had any prejudicial effect since it was not lingering in the jury's mind. If there are no further questions, people request affirmance.
Thank you.
Okay. To your question, Justice Oing, the relevant portion is 299 to 300 of the trial transcript. Redirect begins at page 301. The whole cross-examination was building up to this. This is at the point in the case where Mr. Stallings, he's putting on his defense, he's calling into question the prosecution's case. There is a valid line of cross-examination that the prosecutor is entitled to engage in and does, and the witness satisfactorily responds, and it's only then when the prosecutor intentionally injects this highly prejudicial consideration into the case and then essentially does rest.
Would you agree that not every time that the jury learns that the defendant is in pretrial incarceration, does it mean that the verdict has to be reversed?
I would agree with that, Your Honor.
So what is the principle? What is the dividing line when it does require reversal and when it doesn't require reversal?
Sure. So the case law is, of course, that it's case specific. There are a number of factors that I would point to here as to why this error requires reversal. Going back to your initial question, this was intentional. There was no conceivable reason for it. The door was not opened in any way. There was nothing prompting this question. The way it was built up to, and then cross-examination essentially ended there. And in the context of this case, again, it's not as if there's other Sandoval or Molyneux evidence or a vast amount of evidence to consider here. This should have been a very simple credibility determination for the jury to make. And instead, this propensity argument was injected into the case. This is also not a slip of the tongue or offhand comment by a witness. Many of the cases that affirm mistrial denials deal with a situation like that. So it is highly relevant that this was an intentional action by the prosecutor after really decades of case law making clear that this is just improper.
Okay, thank you.
Thank you.
Dill versus Zoel.
Good afternoon. I'm Stephen Fox from Roble Markham, LLP. There's no denial in this case that the defendant's marketing material contained a material misrepresentation of the facts and of the amenities offered at the building.
How does the offering plan and all the other documents that are attached to this apartment that don't mention doorman, or at least mention the hours of the doorman, affect that argument? You know, putting aside, I mean, you're relying on the marketing material, and say I agree with you. Let's say I agree with you that, you know, they didn't, you know, it was not an accurate portrayal of the services, but you have here the offering plan and other documents that, you know, a prospective purchaser has to do their due diligence. And unless I missed something, I didn't think that those plans or those documents had talked about doormen.
Okay. Well, the only document that said anything other than the marketing material that that the defendants handed out was the offering plan. The offering plan said in there that it is.
Point.
I'm sorry?
The offering plan makes clear that you don't have a 24-hour doorman.
It doesn't. The offering plan says it is an 11-year-old document. It's a 429.
Doesn't section F(I) of the condo offering plan set forth the anticipated doorman hours?
It says anticipated doorman hours. Okay, so it is not.
And it's not a 24-hour doorman.
That was a document that was anticipated before the offering plan became effective. This is 11 years later.
Do you look at the offering plan when you buy a condo like this?
You know, the thing is this: you look at the offering plan at times, but you can't examine every single page of the 429-page document.
Wait,
I'm sorry, I just want to say
she had attorneys.
Yes, she did.
And they don't read the documents?
Well, this
is that what
wasn't.
you're saying?
The attorneys read the documents, but this is not something the attorneys don't know to look at the document for a doorman or not by the time it gets to the attorneys. Okay, this was when the plaintiff was shopping. It said doorman building. She goes 3 times to the building at least, and every single time she goes there, she sees a doorman. Okay, there is active concealment in addition to the fraud.
Section 7 of the contract says that the plaintiff has examined the condo offering plan or waived its examination.
Right.
Section 7.2 of the contract says that the purchaser has expected everything and doesn't rely on any representation unless it's specifically set forth in the contract. Okay. And you're telling us that this was the most important aspect of this deal was to have a 24-hour doorman, and it's not in the contract, and you're entitled to have this treated as if it was?
Well, Your Honor, when she's misled the way that this was an individual purchaser.
You know, how can you know, when you argue she's misled, okay, maybe the marketing materials was not accurate, but I can't, as Justice Friedman and Justice Pitts pointing out, you got an offering plan, it's 400 pages, last I remember when I was a young associate, I used to have to go through each page of those documents to make sure it was said what it says. I mean, so, you know, I can't grasp the point of like, that was just too much to read. We didn't bother reading it.
But when
That doesn't fly in the law.
in the course of an ordinary transaction, this was an ordinary residential transaction. When you go to your attorney, the attorney doesn't know that that there's a misrepresentation about the doorman. They don't see the marketing material. There's a question near the attorney. They see a term sheet. In the term sheet, it doesn't say that they're supposed to.
Right, I'm glad you brought that up, because wasn't there a point where on Mother's Day in May 2022, that the trust beneficiary, Mara Sandler herself, was walking with her children to account, and she decided to stop inside, and there was no doorman on weekend mornings?
Yes, that's how she discovered the fraud, Your Honor.
So was that before the contract?
That was after the contract.
It was
She
after
early-
the
yes,
contract?
that's what that's when once she found that out, that's when she pulled out of she declared the seller in default.
Well, there was about a 3 or 4 month
There was a 4-month, yeah.
delay.
A gap. The contract was signed. She was waiting. There was a gap in between. I don't know what the holdup in the period of time was.
Well, it was in response to the time of the
Yeah, it was
essence.
May 2022, and then August 16, 2022 is when she, the lawyer, so it's like a 5-month delay.
Yeah,
If
well,
this was such a
no,
big
but
deal
what
to
the
her.
record doesn't show is there were things going back and forth. She was, there was correspondence between the brokers. The brokers were giving suggestions, and one of the suggestions from the broker was, you know what, why don't
No.
I'll
See,
give
the
up
thing
my
is,
commission and we'll pay for it.
the way that I read this record is your client that was the big deal, 24/7 doorman.
Yes.
So, you know, from my recall, what clients want, that should have been fired off a letter saying deals off. Not this going back and forth, no offense to the brokers, to talk to the brokers.
Well, there
At that
were
point, it
things
goes to
go-
the lawyers
well,
and say, deals off.
No, the immediate instantaneous response, which is not part of the motions, but it is, it is, the documents were, I don't want it, with that day.
To who?
She said to her broker, I don't want it, and it was fired off within that next, that was on a Sunday, sometime
Yeah,
later.
but like you said, it's not in the record, right? But the best part about it is with the attorneys, you had 2 attorneys on both sides, that should have been fired off to the attorney, right? I mean, that would have been simple.
Counsel, if I may, what, if any, representation was ever made regarding full-time / 24-hour doorman services? Because the only thing that I saw was doorman services, but is there anything that says full-time / 24-hour?
Well, in this industry,
No.
a doorman
No. Is there anything?
There's no distinction on the hours of the doorman,
It
but
doesn't say full-time.
there's a part-time.
No. Is there anything that says full-time? That's a yes or no.
No, but the
Okay.
omission.
No, Is there anything that says 24-hour?
No.
Okay.
But may I just?
You get
the
it on
omission
rebuttal.
of
You'll
the
get it on
fact-
rebuttal. Thank you. You'll get your chance on rebuttal. You can think about the answer. The other defendants other than Zoll.
Good afternoon, Your Honors. Kimberly Johnson, attorneys for Corcoran and Catherine Jurisich. May it please the court. The case is simple, Your Honors. The appellant had a duty to conduct ordinary due diligence under the doctrine of caveat emptor and make a fundamental fact inquiry.
Well, what about the fact that she says that she's been there 3 times and there was always a doorman on duty? How is that not the due diligence?
Your Honor, the appellant did allege in her papers that the agent was silent as to the facts. However, the case law East 15360 Court versus Provident held that mere silence without more does not usually amount to concealment. That is actionable as a fraud unless there is a confidential or fiduciary relationship between the parties, which there is none here because Corcoran represented the sellers, respondent Zoel, or active concealment. There were no facts alleged that my client thwarted Ms. Dill's efforts to obtain.
Other than your marketing materials, your personnel, there was nobody in there actively telling her 24/7 anything about the services, right? I mean, it was just your marketing materials, and I think the strength of what backs you up is that these offering plans basically said you've done your due diligence, you've done your work, and that's it.
Yes, Your Honor. The offering plan does state that there was an anticipated hybrid doorman services, and at that, it's the buyer's duty to ask a follow-up question. As the lower court held, there can't be any reliance on the fact that this term, a 24-hour in-person doorman, was essential to the contract, and yet there's no indication of it in the contract. It wasn't mentioned to the broker. It wasn't mentioned to the seller. This came after the contract was signed.
Well, as to your client, I didn't, maybe I missed it, but I didn't see anything here where the plaintiff went to your client and asked specifically, and your client said, "Oh yes, there's 24/7 doorman."
No, Your Honor, there was no inquiry made to my client.
And assuming there was a misrepresentation, and I'm not saying there was, the contract itself, as Justice Friedman pointed out earlier to your friend, 7.2, makes it clear that there's a waiver here.
Yes, Your Honor.
So even if there was misrepresentations or omission, it's pretty clear contractually they can't find fault with you or the building.
I agree, Your Honor. And to just touch on that, appellant did bring up in their papers that Corcoran and the agent cannot rely on the contracts because we were not parties to the contract, and we did not mention that in our motion to dismiss. We only responded to it in our reply papers because it was offered in opposition by the plaintiff, and so we had to respond to it. But we did not make mention of it. We do not rely on it. Our position is that appellant had a duty to conduct ordinary due diligence and failed to do so, and is now asking this court to shift the burden on the seller and the seller's agent to disclose every single fact, especially something so important on a $19 million contract. It's safe to assume that if it was important to the purchaser, she would have included it in the contract. And as Your Honor so indicated, there was a subsequent intervening act. There were attorneys negotiating the contract of sale. The broker is not a party to that. They're not privy to what goes on in the contract. They only see it after the fact, after it's executed by all the parties. So even still, they were not included in those negotiations and could not have answered any questions unless they were asked, which they were not.
Okay.
Any further questions?
Thanks.
Thank you.
May it please the court, Jason Moabir from Galley, Bryant and Berkey, LLP, on behalf of the respondent, Zoll LLC. As discussed by my co-respondent, the
7.2 gets you out of this. 7.2 basically says, look, whatever the real estate broker tells you, I can't be held liable for it. So essentially, whatever they've done, if it were misrepresentation, you're not liable for that. That's not your responsibility, right?
That is correct. That's how we're positioned, Your Honor, is contract of sale has the disclaimer of the reliance of misrepresentation.
And I didn't see any claims here or assertions that you guys, your sponsor, any of the individuals or principals told her directly that there's a 24/7 doorman.
That is correct. The record has no evidence in regards to my clients actually saying that there was a 24-hour in-person doorman at the building. Again, it's regards to the due diligence. It's the basic due diligence to review the offering plan. As discussed by my co-respondent, the offering plan did demonstrate and did provide that there was going to be a part-time doorman, as well as a virtual doorman when the in-person doorman was not available. There were numerous incidents where the appellant could have actually inquired in regards to the 24-hour doorman when she entered the building on numerous occasions. She could have asked the doorman at that point. There was a point where there were negotiations in regards to prior to signing the contract where the appellant sent a questionnaire to the managing agent, and in that questionnaire, to get clarification about the building, did not even mention a doorman in regards to 24-hour in person. In regards to the contract of sale, it has a provision that specifically relinquishes it disclaims the reliance on anything that's outside of the contract of sale. And with that, Your Honors, I thank you.
That's it. Thank you.
Okay, so the omission of the hours, the word, or the word part-time doorman in the listing is tantamount to saying it's a full-time doorman. That's the way this industry works, and that's the way the listing on Zillow and all the online listings work. When it says doorman, means doorman. Anything else is listed as part-time doorman or virtual doorman. So the fact that it didn't have specific hours or in the listing, it said doorman, and that's what is understood as a 24-hour doorman. There is a
You're representing that as an expert in the field, giving your opinion?
No, that is in that is in the record from, that is in the record. Not representing, I'm not an expert and I'm not a witness in this case, but that is what would show. And if not, this is a matter for the jury to decide then if that's the case, okay? Now, these are people who have superior knowledge. Everyone here knew about the building except the plaintiff purchaser. She knows nothing about this. She's a single woman. She comes in looking at an apartment, says doorman building, doorman's important to her. She sees a
How would you respond to the argument then that if we were to agree with you, that would essentially negate any due diligence on any purchaser's part, right?
No, because I think it's a matter for the jury to decide whether or not she did reasonable due diligence. She went to the apartment multiple times, okay? She saw the marketing material. And then there was the active concealment on the parts of the defendants. The doorman interface, the virtual interface, was inside a cabinet that a Corcoran broker stood in front of every time so she wouldn't even open it. There's deliberate efforts from people with superior knowledge.
It's hard to see the deliberate concealment when the offering plan doesn't make this representation.
Well, the question is how many representations does she have to get, or how many things does she have to see before she has to check every single representation? She saw it with her own eyes.
I mean, you go to the offering plan, there's a table of contents, you start looking around, and it's important to you to have a doorman, so when you don't find it, you would inquire further about it.
But she saw it with her own eyes, so I think it's an unreasonable burden that the court is putting on her to look deeper into it. When someone says there's a doorman and you see a doorman, there's no reason for her to expect otherwise and tell her lawyer, hey, I saw a doorman. She saw it with her own eyes.
In the contract, you agree that you've examined the condo plan.
Yes, but or waived it, and we never got it. The other thing is we never got it. So the fact that she waived it and never got it was also part of the
answer to that, you shouldn't have signed the contract without getting it.
Well, she waived it because she didn't know. You know, these are people, what they're saying is, we tricked you, we lied to you, you fell for it, the burden's on you, too bad.
But is the answer to that, I'm sorry to say, you allowed yourself to be tricked?
Well, when you see it with your own eyes and you're dealing with experts, these people this was a $19 million apartment. They were pretty sharp.
It's sort of like basic that a condo is bound or guided by its offering plan.
But this was a plan hatched by the sellers to trick this woman, and she fell for it. Okay, and it shouldn't be on her. Now, the one thing I just want to point out to one quick thing you said about 7.2, Your Honor, about getting the seller out of it. No, that's not true, because basis yield versus Goldman Sachs says the exploitation clauses or the reliance clauses have to be specific to what the representations made. So a broad, and this court in 2014 came to that. So a broad
You're trying to piggyback on the RMBS cases? That's a good one. Okay, well, we'll look at that one. We'll look at that. Those RMBS cases, they make my hair stand up.
Catch all exculpation or denial of representations is insufficient. And that's what this court has itself held. And the language is very, very clear on that.
Thank you.
Okay, thank you.
Franklin versus Franklin. I think I'll get you out of here before 8 o'clock tonight, so we're good to go.
May it please the court. Stacy Cheslowitz, Rottenberg Lippman Rich for the plaintiff appellant Scott Franklin. The trial court in this case erroneously directed.
So it all comes down to the pay stubs, right? The trial court in its first order said timesheets. There was no appeal taken from that. The second order was, pay up now because she gave you the timesheets and you haven't done anything, so now you got to pay up. And that's what we have in front of us, right?
Yes.
So there's several arguments there. One is res judicata. The issues is gone. It's done deal, right?
So the issue is that in the first motion, the Respondent provided a timesheet. She claimed that she was entitled to reimbursement for childcare expenses based upon this timesheet. The parties entered into, this was a very contentious divorce, and the parties entered into two painstakingly negotiated agreements, one governing support and one governing parenting time.
In the one that governs the support, which is what we're talking about, the issue about pay stubs, was pay stubs ever defined, or should we be taking the common usage of that word? Why isn't there a functional equivalent to pay stubs for people who don't necessarily have that?
So pay stub is not defined in the support stipulation in paragraph 3.2. However, pay stub does have a common meaning in definition in Merriam-Webster's in the Black's Law Dictionary, that it shows payment for services or work performed, and that it shows withholdings. Now, the context is who are the parties that entered into the support stipulation? We have a gentleman in the financial sector and a board-certified orthodontist. These were not two individuals who were naive or did not understand the concept of the term.
That was what Judge Katz was concerned about, the pay stub. She's working off the books, you know, she not gonna have a pay stub. How are you gonna expect her to produce something that she can't produce, where she knows where, you know, the assumption is she is working? So how do you get around that problem?
Well, I think pay stub is only one component of the section, but first to address your question about pay stub. Even if we were to assume arguendo, which we do not believe, that she was working as a household employee, household employees are still required to report taxes. Their employers are required to withhold taxes. So that's first. If for whatever reason her purported employer had said to her, I'm sorry,
I gotta pay you off the books.
my significant other, I am not doing that for you, then I believe it was incumbent upon her, if she wanted to be reimbursed for childcare, to obtain a job for which she could receive a pay stub. But that's only one component. The other components of Section 3.2 require that she be working for remuneration, that she incur and pay, that's the language in the section, incur and pay childcare expenses, and that she be employed by a non-relative. There is no evidence in the record that she ever incurred or paid childcare expenses.
Wait, I thought that the stipulation said that it doesn't matter if she, you don't have to provide a time frame or a period of time. This is just what it is. It's a lump sum that is paid.
The distinction is that she was not required to report the hours that the purported child care provider worked. Certainly, it was a lump sum if she had child care expenses and if she complied with all of the other.
If she wasn't working, then she wouldn't have to pay. He wouldn't have to pay child care expenses.
Correct.
I think. I mean, I understand the way you're saying it, but I don't know if that's how the stipulation was.
I think that in the absence of child care expenses, there can be no trigger to the agreement. It is incumbent upon their
You're
being
saying,
child.
so what you're saying is the pay stub, okay, so let's just assume the pay stub is a pay stub. That was evidence that she was working so that she needed childcare, so therefore I got to get reimbursed for the childcare expenses. Whatever, and that, according to the stip, was $2,000 a month.
Correct. And even though she did not need to provide evidence of the hours worked by that child care provider, a child care provider still had to exist. There is no evidence of that. In fact,
Right, you're looking on the other side. Let's say she did show that she was working, whatever, even if it was a non-pay stub job. We don't have the other side of it where she actually incurred an expense for the child care services.
Exactly, Your Honor. So the pay stub is only one part of the problem. And she represented to the trial court that she had child care expenses on days when the child was in my client's care, on days when the child was at summer camp, excuse me. She really destroyed her credibility here, and I do think that that's a consideration because we're viewing the provisions of the agreement and her failure to comply with them.
So let me ask you this question. You know, when Supreme Court issued their ruling on the pay stub saying timesheets are sufficient, I mean, I looked at the stip. There was some argument about how that might have been a waiver by the attorney, not arguing otherwise in terms of saying, no, it has to be a pay stub, and there was some sort of waiver. And I looked at the stip. It's an interesting stip. It says that, you know, if I waive a condition, that condition isn't waived forever. It can come back again. So, right? So in this sense, it's like maybe it's a snapshot that this may be a problem, or this may be resolved in the defendant's favor, But the next time around, it's still, the pay stub issue is not going away. It's being kicked down the road. Is that
I
a
would
proper
agree.
reading of that stip?
I would agree with that, Your Honor, and I would also state that the first order, not the order that's on appeal, but the first order was a very limited directive. If you look at the order itself and also the transcript, all it directed was the provision of an unredacted timesheet. What do we find out when we get the unredacted timesheet? She's holding herself out as a nanny for her boyfriend.
Okay, thank you.
Thank you, Your Honor.
May it please the court. My name is Evan Secular, Brian D. Perskin and Associates, PC. I represent the respondent, Lacey Franklin, in this post-judgment enforcement.
So this agreement was a hotly negotiated agreement, the terms of it.
Neither counsel nor I were actually the
Whoever was, I mean.
but I would say it was a contested.
I guess that's where the mistake was, right? You should have been there.
I can't speak to that.
There was a lot of back and forth about this. I mean, the agreement as written calls for a pay stub. By what principle of contract interpretation does Supreme Court decide that it can be something other than a pay stub?
The agreement doesn't define respectfully what a pay stub is. And then the agreement goes to.
Isn't pay stub like sort of a commonly understood word? I mean, everyone who's got a job knows what a pay stub is.
I would agree with that, but the agreement specifically outlines what's required to exist in the pay stub.
Well, actually, it doesn't so much say what has to exist. It provides some things which can be redacted out of it. But a pay stub is something which you get, which shows taxes being deducted, that sort of thing, how much who's employing you, that you have an employer.
And I believe that the timesheet that you provided does most of those things. It provides who she was employed by. It provides the hours that she worked. It provides the remuneration that she was receiving. What was provided.
This pay stub, this timesheet wasn't it a Microsoft form?
It was created by her employer. I don't know what he created it with, but it was created by her employer, who happens to be an individual who was employing her for a limited period of time to help out with childcare. So it's not like we're talking about a corporation or some type of formal daycare where she was receiving, what would be a traditional pay stub. What I think the agreement is clear on is what needs to exist. It needs to show that she was working for a non-family member for remuneration. What she was provided does all three of those things. She went beyond that, in October of 2022, by providing the unredacted timesheet and also proof that she was being paid by the bank.
But it wasn't a pay stub, and Supreme Court recognized it's not a pay stub.
Well, I
Supreme
think
Court
then it gets to the argument of what the court decided in its September decision, which is it made a decision that it defined what the pay stub was, and then counsel and her.
Does law of the case bind this court?
I think so, because it wasn't appealed by the appellant. He specifically consented to that definition of what a pay stub was.
But as I mentioned earlier, the stipulation, we can't rewrite contracts. I mean, you agree with us there, right? I mean, the contract is there. So whatever Supreme Court said for this dispute, according to the contract, well, according to the stipulation, that doesn't mean that the next time around that the word pay stub doesn't creep back up and become disputed.
Well, it's a final stipulation of settlement that defines how child care is going
Right,
to work
exactly.
until the child reaches age 20.
No question, right. But the term is the next time she puts in for reimbursement for child care services or child care expenses, right? The ex-husband can bring up the pay stub. I want to see the pay stub because
Yes, it's an obligation that exists each time. She's employed.
Okay, so this doesn't resolve anything. It just kicks the can down the road again, right?
I would argue that the court specifically defined what was acceptable as a pay stub, which was not appealed.
Wouldn't it have been better for a pay stub to be defined within the contract itself so that it's not deemed ambiguous or could be perceived to be ambiguous?
It's one of the classic, we take them as we get them as attorneys, and I understand the position that you're in by saying that, but the contract is clear what the pay stub needs to include, and the document ultimately that my client provided from her employer checks off all those boxes. It shows remuneration, it shows the hours that she worked, It showed that she worked for a non-family member. That checks off all the boxes that are required under the stipulation. Therefore, I think, based on the court's determination, she's complied with the September decision, and then the December decision upheld what the court had already decided.
I know it may seem to hoard the record, but did the employer give her a 1099? Because she strikes like she's an independent contractor here, right?
I don't know the answer to that question.
Because
It's not brought up.
Because that timesheet that you're describing, hit the 3 notes, has no provision for withholding of any taxes that we normally see in
Understood.
payroll,
I
correct?
recognize that, yes.
And it wasn't a payroll timesheet, it was a timesheet that the so-called employer fabricated, created to accommodate, I don't mean that, I meant, in the good sense, created in an effort to try and do the impossible, because there was no pay stub here.
Ultimately, she gave what was provided to her, which in my opinion checks off the boxes under the stipulation, and that's specifically what the court found in its September holding as well as in the December holding. Thank you for your time.
Okay, thank you.
So counsel, what about that? Ultimately, she gave what was required in the stipulation, those 3 things.
Because she didn't. A timesheet is not a pay stub, and there is no proof of remuneration. What she ultimately provided was a single page from a bank statement that showed 3 Zelle transfers on 2 dates that are redacted. Respectfully, given the relationship between the parties.
Well, that's speculative, right? I saw that there was he spoke to the daughter and said.
Certain things are not speculative. We know they travel together. We know they.
Well, don't people travel with their nannies?
Yes, they do, Your Honor, but the existence of the relationship isn't in dispute, and we know that
Is it speculative whether the children were friends with each other?
No, I don't believe that's disputed.
It's not
The
contested.
children are close friends from school, and the parents began a relationship, but to be clear, that's not the problem here. The problem is that she didn't comply with the provision of the support stipulation. If she is in a relationship with someone and that becomes her employer, as long as she complies with those 4 components, then under the agreement, she would be entitled to reimbursement for childcare expenses. But in the absence of a pay stub, in the absence of proof of remuneration, in the absence of childcare expenses, she's not entitled to it under the plain language of the stipulation. And the trial court had no authority to change the terms they agreed to.
I just want to go back to, very briefly, 286, just as to follow up on what counsel here said. What I think would be reasonable then, and it can be done between counsel, I would like to see the employer's name, check. Proof of remuneration, check. Any form of direct deposit with extraneous information redacted and proof that it is not a relative, check. What's wrong with that?
Because once that's produced, we need to see what it shows. What it then showed was that she was holding herself out as a nanny for her boyfriend. It does not prove that she was working, that she was receiving remuneration, or that she had childcare expenses. That is why there was no appeal from the first order. It did not direct any payment.
It didn't direct the plaintiff to do anything.
Correct.
It just said, basically, this is the substitution for pay stub, this is what you're gonna get. But other than that, there was no enforcement, and upon receiving that, you need to pay X, Y, and Z.
That is the critical language that was not.
Only in December is there an order which requires him to do anything, and he appeals and moves for a stay.
Correct.
Okay.
Thank you, Your Honor.
Thank you.
Was it down the hall?